Absolutely. It's a tall order because that is what it is. The basis of that is what a Latinate expression, interest republicae, puts it finis litigation.
You love your Latin.
Yeah, that's in the interest of the republic that litigation must come to an end.
That's right.
At some point. And that we can see the difficulty with the Supreme Court when it exercises its original jurisdiction. That can be sort of a challenge to that principle. Because then generally, if the case goes through a number of courts, is on appeal, high courts, blah, blah, name it and counts, you think that, look, it must come to an end at some point. But with the constitutional interpretation, we've decided that then we can have some sort of a review, not just with constitutional review, but I'm saying that in that arena, that's what you get. And that review, considered by as many as 5 people at a minimum, in this particular case, 7 people who have gone through whatever it says they have considered, we think that you must have a good basis to seek a review of it, which is that we get a second bite of the cherry. So it is a difficult exercise. Nobody can deny that. Exceptional circumstances. You will have to even convince the court that these things that I consider exceptional should be exceptional to you. And in addition to that, that you sitting there listening to me was involved in a miscarriage of justice. I mean, as one leg, and also a new important matter. And they have emphasized, I was just looking at Republic versus High Court General Jurisdiction case in 2020, where the court, I think it was Chief Justice himself, was very clear, citing previous authorities, that the Supreme Court will not permit a review to be a rehearing of the matter, where they were distinguishing between an appeal and a review. And the Supreme Court has done that consistently. If you're on appeal, it is a rehearing. We can decide to look at the record. In a review, we can look at the record only when those exceptional circumstances arise. Otherwise, you must show us these 2 things. And I'm sure that Alaji knows that. Osman knows that. Everybody else there knows it. It's part of our training. We know it. And it is the rules by which we play. At this stage, if Alaji can show us those exceptional circumstances and miscarriage of justice, discovery of new material and all of that, then I think that the Supreme Court should hear him. I am not worried about whether he will end up with a 7-2 or a 9-2 or 7-2, right? Because you had 2 more, so you get a 9. And a 7-2, or that you get an 8-1, or you get what? That is not my worry. And so I will not say don't go simply because 7 have already done it. His challenge at this time is to convince himself within the period that he has, is a month or so.
Yeah, 30 days.
30 days. To convince the court that he can find these. If he cannot, so be it. This is the state of the law. And this
the door is shut.
Yeah, the door will be shut. But look, I think that we should have better minds to a certain provision. You know, a lot of the time I hear this point being made that, look, the Supreme Court did not have some old decision to go by, or that there was no guide on them. But that is why it is the Supreme Court. That is the reason it is the Supreme Court, actually.
But you know, as a lawyer, it's difficult when you're arguing and you can't have precedent to fall on.
Absolutely.
I've done one such case recently, and it's difficult.
Absolutely.
You must engineer the new arguments.
I love that, actually. I prefer that. A lot of the time, the so-called precedents do not deal with the issue the way you are bringing it before the court.
Right. Times have changed.
You've had so many discussions. People have talked about standing. People have talked about the participation of Parliament in this matter. People have talked about the political question doctrine as it applies. People have spoken about the standing orders.
People have questioned why the Attorney General, who represents and is a political appointee,
is now appearing on behalf of Parliament, which is a different arm of government.
Appearing on behalf of the people who are coming to the court against.
Because he's an advisor to the executive. Not to Parliament, and that becomes a matter. And then people question and all that. Look, the political question doctrine in particular, which is a very key discussion in this, has featured in the Supreme Court judgments of this country as far as judicial review is concerned on so many bases. Yes, in Tufon Attorney General Sowa read the judgment. He never used the expression political question. So I'll leave that, even though he did a lot of analysis that formed the basis.
In simple terms, what is political question doctrine?
Okay. So as I was saying, 20 years ago, when we were all reading these matters, we saw these cases and these references and all of that. Even Baker and Carr is on the, at the law faculty Legon. Baker and Carr is part of the cases on the course outline. We went through it and touched on it. But I must tell you, that it is in studying for and taking the New York Bar exam that I really came to appreciate some of these things. And Kwesi Prempeh in particular, HKP, I've known him for over 20 years. An extremely bright fellow. I'll set him apart, tell you the truth.
He says this judgment is fidelity to the text and structure of the Constitution.
I agree with him.
Even though he has some issues and calls it messy, including the Attorney General representing, as it were, the other side.
I'd like to say quickly that the Attorney General representing the other side is not a problem in the eyes of the current law. What he is saying sounds more like a recommendation to me. The point is that, can you fault the fact that this is what happened? Is he saying that he faults?
But the Supreme Court has had cause to say that it's not in every situation that the Attorney General can competently represent an institution of state.
I agree.
Yes,
so for the Attorney General,
because the Attorney General's, as it were, position may or will conflict with that entity.
Samson, don't misunderstand me.
Right.
I agree with Kwesi Prempeh's point. I am saying that he cannot tell me that for that reason this judgment is defective.
Okay.
That's the point I'm making.
He doesn't say that.
Okay, I am saying that structurally, I agree with him 1,000%. That we have an Attorney General who is a member of the executive, clearly a legal advisor to the president, etc., representing the matter featuring parliament. It's a place we should look at. It makes a lot of sense to me. But I'm saying that it is on that basis. We cannot say that because of that this judgment has been rendered nugatory. I hope you get the point I'm trying to establish. That it does not become nugatory only for that purpose. That it makes a lot of sense to say that in matters like this, perhaps we should look at somebody else doing the representation, all of that.